Thank you so much. I thank you very, very much. Teresa, that was gracious and generous, and now I should say thank you and tell you to go to your sessions and then sit down, but I'm not going to do that. I just have a few things I want to share with you this afternoon, but I remember when Teresa said, stand up, all of those who've graduated or who's graduated within the last 2 years or are students. Judge Pat Wall sitting next to me said, she missed me by a year. And we claim that. We claim it now. I understand, Teresa gave me a very generous introduction, but I hope icons are not old. We struggle with that. I mean, we struggle with that. My home is Norfolk, Virginia, and a museum contacted me. Elaine, we're starting the African American Museum in Portsmouth. Please send us something, Now, you all have been generous over the years. There are boxes of plaques, but brothers and sisters, ladies and gentlemen, psychologically, she's not ready to go in the museum. And I just want you to know I am working on it, and in time, maybe. Now, I received from the American Constitution Society, I just want to say about ACS, this board of directors and board of advisors and the chaplains, you are all wonderful. I am so grateful to look around the room and see all of this help that is so desperately needed on these issues. And we are going to assert ourselves and change this thing. I mean, we're going to do that. Now, as I think about the board of directors and board of advisors, I have dear friends throughout that board. And Lynn Huntley on that board called me up and asked me to come and give this talk this afternoon. I said, Lynn, you are testing the friendship of Saturday afternoon in the middle of the summer. But this is something I want to do, and so I thank you for giving me the opportunity. Now, I received from ACS the document, which is the guidelines and release for convention speakers. And I understand the issues of the board and everybody else. As a tax-exempt educational organization, while we are free to promote or criticize ideas or policies, we cannot support any statements or activities that constitute endorsements of candidates or political parties. No problem there. These restrictions apply to all events or publications hosted or sponsored by ACS. Understand that, camera, that's true. Thus, we ask that you please refrain from expressing any views that could reasonably be interpreted as in endorsing any candidate or party in an election. This guidance should in no way restrict your selection of issues to discuss. See, Lynn didn't tell me about this challenge. Issues to discuss or the style and manner in which you share your opinions. So this is the mandate, and Elaine is going to do her very, very best. That's all I can. Now, I'm going to give you several random thoughts that are on my mind. And it has to do with the courts and the nomination and confirmation process, and Voting Rights Act, a word or two, and then I'll sit down. But I want to start with something your dinner speaker tonight, Larry Tribe, I assume he's still the dinner speaker, wrote 20 years ago, 1985, a book called God Save This Honorable Court. And in it, he developed an argument for making the issue of balance on the court a legitimate issue. He discussed that the context of a nomination should be considered along with the views of the nominee, and if the appointment of a particular nominee would push the court in a substantive direction, this is a quote, that a senator conscientiously deems undesirable because it would upset the court's equilibrium or exacerbate what he views as an already excessive conservative or liberal bias, mandate, okay, then the senator can and should vote against confirmation, close quote. He went on to say to vote otherwise would be to abdicate a solemn trust. He went on to posit that a consideration of balance could work not only against the nominee, but in his or her favor. If, for example, the court was seen to be moving strongly away from the nominee's views, it would strengthen the argument for confirmation. And so, of course, this is, as Ethan Bronner went on to discuss in his book, it's a more complex view of the role of advice and consent than the Senate had previously existed in a formal way. And in other words, Tribe was telling us that the senator's job was not simply to rubber stamp a president's choice or to satisfy himself that a judicial nominee's integrity, intelligence, and even philosophical leanings were to his liking. The legislator had to make a still broader evaluation of whether the nomination would be good for the court and the country at that time. In Tribe's view, a nomination that would be appropriate in 1 year might be ill-advised 5 years later because the court could have changed. Ask him tonight if he's still of that view. I'm interested in knowing because, in my view, this argument, especially today, needs to be considered with vigor. There is no left on the Supreme Court of the United States. Brennan, Marshall, Douglas, there's no left. There's the far right, there's the right, and there's a middle, but no left. Now, all of this language that we get about strict construction. Now, we get arguments from conservatives for strict construction of the cruel and unusual punishment clause, 8th Amendment. However, we get arguments for expansive construction of constitutional provisions they like, such as the takings clause, 5th Amendment, the 11th Amendment, restriction of judicial power in suits against states, the commander-in-chief power of the president, Article 2, Section 2, Clause 1. When is the last time you heard a strict constructionist call for a strict construction of the president's powers as commander-in-chief or his authority in foreign affairs? You haven't heard that. You're not going to hear it. So it's when it serves their purpose. Now, yes, the president has the power to nominate, Article 2, Section 2, Clause 2, by and with the advice of the Senate. But here's one thing that I just want to put on the table. Why don't we listen to what any president says when he nominates? Why don't we believe him when he gives us his intent? When he says his intent, we don't have to divine his intent or figure out what he wants to do. He tells us. And also, when he tells us, the nominee often tells us. Now, the African-American justice who sits on the Supreme Court, he never lied to us about any substantive issue. He never lied to us about any stuff, what his views were. He ran around the country giving speech after speech, lambasting the Voting Rights Act, Thurgood Marshall, anything else he could talk about. I mean, the record was there. LDF knows we reviewed it and filed a 200-page testimony against him. So the record, but we chose not to believe. Too many chose not to believe. Oh, he couldn't mean that. He's playing politics to get on the court. You know, that's the only way he can get up there. That's what's the thinking. Now here we have a president that tells us he wants his nomination and his nominee to be akin to whose philosophy on the court? He said it. He said Justices Scalia and Justice Thomas. That's what he said. Did the president not do what he intended to do? Did he not mean it? It's the same thought process we're going through. It is ridiculous. The president has told us what he wants. Why are we here thinking that he's got something other than what he told us he wanted? Now, sure, as lawyers, believe in facts, got to look at the record, got to do all the things that lawyers do. But isn't there some sort of presumption that he is more like Scalia and Thomas than like O'Connor and Souter? I mean, all right, I just put that out there for you to think over. Now, this whole question of, ideology, I mean, it's what I have found as I have run into some of these judges on these courts, or in close questions, or questions not so close, involving individual rights, privacy, personal liberty, due process, equal protection, causes arising under the 14th Amendment, 8th Amendment, interpretation of the civil rights statutes. No matter what evidence you marshal, no matter what legal arguments you posit, it doesn't really matter whether the weight of legal precedent favors or disfavors your position. No matter the quality of your briefs and the brilliance of your argument, you can predict with virtual certainty, as steady as the ticking of the clock or the setting of the sun, you can predict what that judge or justice will more than likely decide. That's ideology. That's ideology. It makes our role as advocates a sham. I call it repeal by nomination. It's the nomination is a statutory repeal of a whole set of rights, so we have to be clear about what we're talking about. The mind is already made up, although people will go through the motions. That's all that's happening. Being polite and civil and genteel and courteous. But you can count that as a vote against you. That's a problem. That's a problem. Now, let's talk just a minute or two about the clients you represent. I've heard an argument that all lawyers are not responsible for the position of their clients. We represent clients. Elaine Jones has represented clients. Her 32 years at the bar, that doesn't mean she has a position on affirmative action. I've been representing clients. I've been, that's what I've done. Now you're laughing at me, but in others are using this argument. And that's right, I don't think it passes the laugh test because it's the same thing. Clients, now, we understand that an attorney's views are separate from her client, where she just takes on an unpopular client out of a sense of professional responsibility. Atticus Finch representing Tom Robinson, To Kill a Mockingbird, we got that. Or she regularly represents a client who at times has a problem that requires advancing a view of the law that the lawyer doesn't necessarily agree with. We understand that. However, when someone joins an administration as a lawyer, as a political appointee, not a civil servant who serves both parties, she does so to advance the policies of that administration, doing so as a lawyer. You can't claim you were just advancing the client's views when the lawyer chooses the client and did so precisely because of those views. The lawyer may not, of course, agree with every policy, but it is fair to conclude that she does agree with most of the positions she advances, because if she did not, she would not be working for that administration and trying to advance its policies. The point I will make here is that anyone who went to work in the Solicitor General's office well knows that she took that job when this was one of the main policy goals that the administration was going to try to advance in the court. Some folks whose choice of clients were clearly about the causes those clients were for, no one would buy the suggestion that they were just advancing the client's view. Now, let's just have just a few quick examples of that. William Jennings Bryan, remember him? Lost to President McKinley, 1896. He was the youngest person to ever receive the nomination for president. 36 years old, got 47% of the vote to McKinley's 51, and he was nominated twice again, in 1900 and 1908. The man wanted to be president, y'all. It didn't happen. And so when Woodrow Wilson became president in 1912, Bryan became his Secretary of State. And then he resigned in disagreement with Wilson's decision to push the country toward involvement in World War I. But once he left the administration, William Jennings Bryan devoted himself to advocacy of social reforms. And the source of his fire came from his deep Christian faith. His politics, in fact, have been described as applied Christianity. Bryan grew concerned about the influence of teaching evolution in the schools. He defined evolution by 1920 as the most paralyzing influence with which civilization has had to contend during the last century. Speech after speech. So here we go, the arrest of John Scopes, 1925, for having the nerve to teach evolution in the schools. Brian received a wire from Scopes' attorney asking him to join the case and work with him on behalf of his World's Christian Fundamentals Association and in upcoming trial. And it'd been 30 years since Brian had last appeared in the courtroom, but that didn't stop him from going associating on this case. He boarded the train and arrived in, it was in Dayton, and I mean, he was busy, made speeches in court and arguments and the whole thing. Now, William Jennings Bryan, and his involvement in John Scott, can we say there that he was simply representing the client? He was asked by counsel to co-counsel on the case, so he did. And so we can't assume from there that he had any particular connection with the issue beyond this representation. Another extraordinary gentleman. Graduated from Washington Lee University, graduated from law school in 1895, law class orator, ordered the court, professor of law at Washington Lee University, elected to the West Virginia House of Delegates in 1899, represented West Virginia for 2 years in the U.S. House of Representatives. Solicitor General of the United States from 1913 to 1918 during Wilson's administration again. Member of the American delegation for conference with Germany, appointed ambassador to the Court of St. James, served from 1918, 1921, rejected the appointment to the United States Supreme Court in 1922, was asked if he would deign to serve on the high court, and he said no, he was making too much money, and so he couldn't do it. Democratic candidate for President of the United States in 1924, made 140 oral arguments before the Supreme Court, which was a 20th century record. At his death in 1955, he argued more cases as a private attorney than as Solicitor General. 14 honorary doctorates, President of the American Bar Association, all of it. Opposed some of the most important civil rights battles of the 20th century. Anti-lynching legislation, women's suffrage, child labor laws, and President Truman's civil rights program. I'm talking about John W. Davis, Thurgood Marshall's opponent in Brown versus Board of Education. John W. Davis argued on behalf of the state of South Carolina in Briggs. The state asked him to be counsel. And John W. Davis died in 1955. But John W. Davis stood in the well of the court, and tears came from his eyes. Tears. Southern way of life. You know, and how the court needed to be very, very careful in what it would do in this decision. I mean, and gave it his best. Gave it his best. And I just want you to know, this is one African American who's very happy that he lost. But you can argue John W. Davis at the top of his game, representing the client. All right, now, just a couple more for Judah Philip Benjamin, 19th century legal star. 1811, 1884 was his lifespan. He was born in the Virgin Islands. Then he moved to New Orleans in 1828, was 17 years old. Brilliant intellect, brilliant. Rose to distinction, studied law. While a clerk in a notary's office, admitted to the bar, became a joint author of a digest of high court decisions, became a leader in the Louisiana bar, specializing in commercial cases, sugar plantations, large business enterprises, entered politics, Whig member of the Louisiana legislature. Again, declined an appointment to the United States Supreme Court. This is an interesting group. So, from 1853 to 1861 in the U.S. Senate, became widely known as an orator and conservative social leader, joining the Democratic Party in 1856. Vigorous, resourceful, he found time to appear frequently before the United States Supreme Court and became recognized as one of the foremost American lawyers. Late 1860, joined the secession movement and was appointed Confederate Attorney General in 1861. Because of his ability and growing influence over the Confederate President Jefferson Davis, he was made acting Secretary of War, then full secretary, became Secretary of State of the Confederacy in March 1862, became Jefferson Davis's closest advisor till the end of the Civil War, and had a harrowing escape to London, was able to get out. And when he escaped to England, he claimed British nationality in 1866, studied for the English bar, wrote a treatise on the law on the sale of personal property in 1868. Within a decade, he became a leader of the English bar. His career ending with death in Paris on May 1884, one of the most remarkable examples in modern history of successful struggle against adversity. Attorney General of the Confederacy, Judah Philip Benjamin. He's representing the Confederacy. That's all. That's his client. Jefferson Davis is his client. I just want you all to get this. Now, just like the head of the Washington Legal Foundation, Cameras, talking about everybody, established in 1977 to, quote, fight activists, lawyers, regulators, and intrusive government agencies at the federal and state levels in the courts and regulatory agencies across the country. And so that is Mr. Pompeo, is that it, right? Pompeo, Daniel Pompeo. Well, he's head of the Washington Legal Foundation. I was head of the NAACP Legal Defense Fund. And we took these positions to represent our clients on affirmative action when we fought against each other. But we represent our clients. You don't know what my view is on affirmative action. I'm sure you don't have no idea. What is it? All right, now, that's my few thoughts on that issue of your client. Other part I want to raise is brilliant is not enough. Brilliant is not enough. Brilliant is important. Stupidity is too much. Brilliant, though, is not enough. We're not going to discuss that spectrum in terms of the court. All right, now, brilliant. Who do we have brilliant? We have graduated first in his class from Dickinson College, admitted to practice in 1799, Maryland General Court, elected to the Maryland State Legislature, elected to the Maryland State Senate, private practice in Baltimore, Attorney General of Maryland for 4 years, appointed Attorney General of the United States for 2 years, 1831, 1833, U.S. Secretary of the Treasury, 1833 to 34. He is viewed as one who made an enormous contribution to the development of the law. One little problem here. Chief Justice Roger Brooke Taney. There was a grievous injury, a grievous stain that he put on the court with Dred Scott. I mean, that opinion did not have to be written. I mean, and the first idea was to write a very narrow opinion. still saying that Scott was a slave, but you didn't have to go into all of this, reaching constitutional questions they didn't have to reach. And so, his first thought was the right thought. The court had a conference and had decided initially that they were going to write the narrow opinion, but then he changed his mind. Got to be careful about second thoughts. Changed his mind and then wrote this expansive decision. And he authored it. But he had the two dissenters in Dred Scott. Lesser lights, but dissenters got it. John McLean and Benjamin Curtis. Benjamin each wrote a separate dissent. Benjamin Curtis got so disgusted with this, and he could see the wrong of it. He resigned. Had only been on the court since 1851, but in 1857, after 6 years, he just stepped down. He said, I can see this problem, and I don't want to be a part of it. Taney was up there 28 years, and many say that, he did extraordinary work. It's interesting. It's interesting when Taney died, I think it was 1864. Yeah, I think that's right. He was 87 years old, and because he was when he announced the decision, he was elderly, because that was in 1857, and he just spoke. You could hear his voice failing and all, but he got that opinion out there. And it was interesting that the decision came up in the Senate. They discussed whether or not they should put this marble bust in the Senate chambers. And so the motion was made by a senator to put the bust up there. And Charles Sumner from Massachusetts, we all know Charles Sumner, Senator Sumner stood up and said, I object that now an emancipated country should make a bust of the author of the Dred Scott decision. And Senator Trumbull, the senator from Illinois, said, well, Taney presided over the court for more than 25 years. And we trust that a bill to honor the man who had added reputation and character to the judiciary of the United States. That his views were hooted down. That was a sharp retort from Senator Sumner, said the name of Taney is to be hooted down the pages of history. And he administered justice at last wickedly and degraded the judiciary of the country and degraded the age. Well, it was too much for Senator Johnson of Maryland, Taney's home state senator. He said, just a minute, and there's some truth. He said Taney was a lawyer and a lifelong friend, and I'm a lifelong friend of Taney's, and he told Senator Sumner, Senator Johnson of Maryland did, that I doubt that you will fare as well among historians as Taney has. And Johnson offered this spirited defense of his friend. Well, Johnson's words were no avail. Henry Wilson of Massachusetts and Ben Wade of Ohio, the two senators, spoke out against the allocation of the $1,000 for the bus. And they remarked, the Senator Wade of Ohio remarked that his Ohio constituents would pay $2,000, and we're nonviolent, to hang this man in effigy rather than $1,000 for a bus to commemorate his merits. But passions cooled, and so in 1873, when Salmon P. Chase, who was Taney's successor as Chief Judge, died, very quietly, Congress, without debate, approved the money for marble busts of both deceased Chief Justices. Well, when I say brilliant is not enough, I'm just trying to give you some idea of the issue. Samuel Miller, Supreme Court of the United States, 1862 to 1890. Miller, during his service on the court, Miller participated in more than 5,000 cases and spoke for the court in nearly 100 constitutional decisions. He set the record for his time for the most constitutional decisions authored by a single justice. And he, in those decisions, he could not see that Myra Bradwell could become a member of the Illinois bar. I mean, Uh, Myra Bradwell, the first woman, become a lawyer, tried to become a member of the bar. Her husband had helped her, and they moved forward, petitioned the court, Illinois Supreme Court. She met all the qualifications. And then Miller writes this paternalistic opinion about women's role in society as one that should be subservient to men, relegated, their natural and proper timidity and delicacy belongs to female sex, evidently unfits it for men of the occupations of civil life. And, he just went on and then gave us the slaughterhouse cases the next day and all. So this is Miller. This is Miller. Brilliance is not. Now, that's being responsible for your cases. Brilliance is not enough. Now, civility. There's a role for civility. I'm Southern, y'all. I believe in it. Believe in it. But let me give you an example that's just to the extreme, and I'm going to talk for another 8 minutes and try to sit down. But listen. Big case came out at Maryland. Poberesky, the scholarship program, Benjamin Banneker Scholarship Program, University of Maryland. Maryland Sue Sponte came up with the program because they had all these years of discriminating. Public institution, it says, look, we discriminated, and when we didn't admit Thurgood Marshall, we're awful. We need to do something. So we're going to set up this scholarship program for black students. Take 1% of our scholarship money and do it. And of course, it was challenged, and they're very interesting when they do this. This time they found a Hispanic student, and so the issue was joined. And so the Reagan appointee, Judge Marks, the case was litigated, tried, came out with a decision in 1994 ruling for the program. 58-page decision. He said these issues are tough, but we have to struggle with them and do the best we can and look at them in context. Fine. Goes up to the Fourth Circuit Court of Appeals. Now let me tell you, Fourth Circuit, I know the Fourth Circuit. Oh no, Justice J. Harvey and I were in the same class at law school. We have exchanged correspondence in the past. All right, now, we go up to the Fourth Circuit, and in the Fourth Circuit, there's the legal defense fund lawyer, Janelle Bird is standing up there, arguing Poberesky in the circuit. Her panel are Judges Widener, Wilkins, and Hamilton. While she's arguing, they're in discussion with one another, as if she's not standing there. As if she's not there. She is arguing one of the most important cases to students and the whole question of scholarships to students of color, and they aren't even listening. I mean, they're not just asking one another questions, they're in conversation among the three of them. When her argument finishes, they follow the Fourth Circuit tradition, which is what? Come down off the bench and come around and shake hands with counsel. Don't you all see the point? Civility. Listen to my argument. Listen to my argument and think about the issues. If you want to give me an add-on and come off the bench, fine. But don't substitute coming down the bench, shaking my hand for listening to my argument. And too much of that. All right, now, importance of politics. Still within the guidelines, y'all. Importance of politics. Quote from Justice Thurgood Marshall. Justice Marshall told us, he said, quote, back in the 30s and 40s, we could go no place but the court. We knew then the court was not the final solution. Many of us knew the final solution would have to be politics, if for no other reason politics is cheaper than lawsuits. Well, it may have been, but I don't know. That's debatable. So he said, went on to say, now we have both. We have our legal arm and we have our political arm. Let's use them both. And don't listen to this myth that it can be solved by either or that it has already been solved. Take it from me, he said, it has not been solved. Now, it was so nice of the RNC chairman. How am I doing within the guidelines? So nice of Kenneth Melman, the RNC chairman, to give remarks at the NAACP National Convention. I mean, just went on about how the party of Lincoln and the African-American community have a proud history together. You know, party of Lincoln, not anything that Lincoln wrote, but the party of Lincoln. Our party was founded to eliminate slavery, he goes on. And our first Republican president was Abraham Lincoln. And it was Republican, I'm quoting from the speech, Republican President Teddy Roosevelt. Luckily, I wasn't there. Because, of course, luckily, because I knew all of this. And it just went on. He said, in the past, Republicans gave up on winning the African-American vote, looking the other way, and trying to benefit politically from racial polarization. I'm here today as a Republican chairman to tell you we were wrong. I have one problem with that sentence, the tense of the verb. Now, and so then he goes on and on and on and on, you know, and on. And which brought me to the question of the Voting Rights Act. And I'm just going to say this as I sit down. The Voting Rights Act was conceived, we all know the history. The poll taxes, the literacy test, people shot, killed, maimed, murdered, folk who died on courthouse steps, returning vets from World War II killed at home simply trying to register. You know, it's a whole list, and it's most throughout the South. People of both races, different religious faiths. So it was a struggle. I mean, a real war. And so now the Voting Rights Act is within law to try to undo some of that damage and to make sure in a prospective way that we don't fall back into this problem. And so it's a way to monitor what's been going on. But now, you know, after Reconstruction, you had several blacks elected to the Congress between 1875 and 1901. You know, blacks in the U.S. Senate. I mean, all of that, but Reconstruction turned that all around. The last black to leave the Congress was George White of North Carolina on January 29th, 1901. He said, Mr. Chairman, this is perhaps the Negro's temporary farewell to the American Congress. But let me say, Phoenix-like, he will rise up someday and come again. These parting words are in behalf of an outraged, heartbroken, bruised, and bleeding, but God-fearing people, faithful, industrious, loyal people, rising people, full of potential force. Now, he said, the only apology that I have to make for the earnestness with which I have spoken is that I am pleading for the life, the liberty, the future happiness, and manhood suffrage for 1/8 of the entire population of the United States. Now, let's keep in mind, here I'm talking about the African-American struggle to vote. There have been all kinds of struggles. You know, I think about the Mendez case in California, Latinos trying to get their children a quality public education in Orange County, California, back in 1945. You know, they filed that lawsuit then on behalf of their kids. And luckily, it was a federal district court judge who was not ideologically driven who understood it. You know, they won at the appellate level. The case didn't have to go to the Supreme Court. They won at the trial court, and the Ninth Circuit affirmed. The Mendez case, pre-Brown. Look at the Asian parents. Back in 1925 in Gong Long versus Rice down in Mississippi, this little girl, 9 years old, shows up to school in 1924 to go to school. And the superintendent shocked, because, I mean, you know, Chinese Americans in Mississippi in 1924 were not a big population. And so he was stunned, the school superintendent, when he saw it. So he summoned up the courage at noon to call in and said, well, you're a yellow student. Something she didn't know. You're a yellow student, and you cannot come to school with white students, is what he had to tell her. And lawsuit was filed, and what the Supreme Court got it wrong. Said, we have looked at this question over and over. Now, this is 27? We've looked at this question over and over. This is 25 years before Brown. They looked at this question over and over, and looked at it, and hadn't decided anything but blessing. But anyway, so my point is about the struggle of women and Latinos and African Americans, and now the disabled and the elderly, all of the issues that we care about. And what happens is not a zero-sum game, this issue of rights. If we let them limit our rights, all of us are diminished. And so I do disagree. I have the temerity to disagree with Judge Bork on that point. He thought it's zero-sum game. If you give rights to some, you restrict them from others because it's only so many rights. Not quite my view. All right, now, let me end with this. We have work to do. I am so glad that you are that you are here and that you engage. We can make a difference. There is nothing that we can't do to change this system. I like to think Greta would not have happened if the Supreme Court of the United States had been able to decide the Piscataway case. The Piscataway case out of New Jersey, white teacher, black teacher, stipulation that the black teacher got the job because of her race. Meanwhile, the little fact that she had a master's and the white teacher didn't even make it into the record. So we're in the Supreme Court on this stipulation. I'm confused about that case. You can tell what Justice Scalia would do to it. And that would have been the end of the struggle. And I said to myself, we weren't even in the case. I woke up 4 o'clock one morning, Supreme Court had granted cert. Argument scheduled. I said, that case got to settle. I'm looking at the dark room. I said, that case has got to settle. And look up to whoever we believe in this, and now you have to help me do it. And it settled on the eve of argument. Case settled on the eve, and a lot of these cases just had to move out of the way. University of Georgia, the record wasn't made below on affirmative action. Why are you going to take that case anywhere? University of Texas, the Attorney General didn't know his client was supposed to defend the affirmative action plan, not attack it. Your whole issues, those issues. And so, you have to, if your issue is important than that, you have to get the case in the court fully briefed, where everybody's worked together below, where you've developed a record. You don't want to be up there on a summary judgment. You really want to fully develop the record and have a trial, flush out the issues. So, what each of us can do is important. Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has. On the Voting Rights Act, I want to say this, and all of you who know the ins and outs of the act. When Melvin came, talking about the politics and all, felony disenfranchisement is a huge problem in this country. It's a huge problem. Now, what Mr. Melvin can do, go talk to Governor Bush and tell him with a stroke of a pen to enfranchise those who have served their time in the state of Florida and make sure they have the right to vote. That's something you can do to show us you're sorry. Just go down to Florida and talk to Bush and tell him the whole host of issues, that act, Section 203, the bilingual provisions, all of it needs to be strengthened. But something else. My friends who understand the whole redistricting process and the pre-clearance process and retrogression in Georgia versus Ashcroft, you know who you are, you know what that means. Let me tell you, the Voting Rights Act is not there to protect the interests of a political party. That's not what it's there for. It's there to protect the interests of those disenfranchised voters so that they can elect the persons of their choice. Now listen, I know political realities. I understand it's the Congress that has to expand and extend the Voting Rights Act. That's not the point. We are advocates we don't compromise before we start. And our position we are not the Congress of the United States. We are advocates, and we need to make sure that the purpose of the act to protect the right to vote so that disenfranchised folk can elect new people to Congress if they choose. If they want to elect new people, they can do it too. It's not an encumbrance protection act. And so anybody who comes to me, now speaking of coming to me, because of the rule, I'm a member of a sorority, and the elephant is our symbol. And I was going to put the elephant up here, but I said, no, I don't have to go quite that far. I don't put the elephant. But then I said, I'll put my Lady Justice pin that Mrs. Thurgood Marshall gave me. Sometimes the only place I can find justice is up here on my shoulder. Notice it's on my left shoulder. But let us remember what our job is. We are advocates, and we should have a core set of values and principles from which we will not retreat. Otherwise, we fought and fought and fought to get strong statutes and strong laws. Do you know Mr. Reagan signed the Voting Rights Act extension? Do you know Bush 41 signed the Civil Rights Act of 1991? Didn't want to do it, signed it. Vetoed it first, it came back next year, signed it. What I am saying to you is don't forget, as advocates, you've got to stand your ground. And you don't start off talking compromise, because then you end up with something you don't even want. It's not even worth having, and you no longer even have an argument. So I thank you for this opportunity to speak. I thank you for your imagination, your genius, your intelligence, and your creativity. I know you will harness it. I know you will use it. And Margaret Mead wrote, that societies are renewed by people who believe in something, care about something, and stand for something. We are community. What is community? A sense of shared joy and pain. But with our collective work and with our making sure that we do not let ourselves be undercut and divided and pitted against one another. Teddy Roosevelt had his problems, but he gave a great speech. This speech, man in the arena, and I paraphrase, woman in the arena as well. The credit belongs to the man or woman who is actually in the arena, whose face is marked with sweat and dust and blood, who strives valiantly, who errs and comes short again and again, who knows the great enthusiasms, the great devotions, and spends himself or herself in a worthy cause, and who, if he or she fails, at least fails while daring greatly, so that her place shall never be with those cold and timid souls who know neither victory nor defeat. We will know victory. Thank you all very, very much.